of time and things are not going to go the way you thought they were in court. Please share your thoughts on this one. I'm going to love reading these comments. Like and subscribe. Set your notifications.
That's appropriate to say at this time.
I mean, yes, but I mean, it's set for a contested, so it's going.
Well, I wanted to bring something to the court's attention,
Okay.
if I may. Mr. Ross and I, as the court was probably privy to, are not on the same page. And very
No, I made mistake.
Just 1 second.
Wow, check out this defendant strategy. Arguing with his own attorney, calling out officers, and basically trying to charm Judge Boyd. Classic court chaos. Comment below, have you ever seen someone try all the tricks at once?
No, I made mistake.
Just 1 second.
No.
All right. So any questions, defense or state?
No, Your Honor.
Well, here's the thing. We don't shout in court, right?
right.
You got to be respectful to your attorney and respectful.
Productive or civil for me to continue representing him.
I mean, I understand what you're saying, counsel, but we were here in August and it was set for a contested hearing for October 9th.
Mm-hmm.
And then it was reset for today for a contested hearing. So the state has their witnesses. We're going to proceed.
I guess I'll.
Here's a key moment. The judge is reminding everyone that respect matters in court. Shouting at your own attorney? Not a winning move. You can already feel the tension rising. This is where things start to unravel.
I'll say this, if I may. We're not getting along. I think it's very much affecting my wanting to and desire to represent him because I don't want to be cowered over and yelled at.
So here's the thing. You can't be yelling at people. That's it. So your attorney is here to represent you. You have a motion to revoke. You're on probation for possession of a controlled substance, penalty group 1, 4 to 200 grams. Your underlying is 8 years. So that means if the court were to find the allegations within the motion true, then you're looking at 8 years. Now, if you want to shout at your attorney, I don't know why you would do that. I don't know why you would raise your voice to your attorney. That's on you. But I can tell you what's in this motion to revoke. Just one moment.
Now pay attention. This is serious. The defendant is facing up to 8 years for probation violations. One wrong move here could dramatically change everything. That's why these hearings are so high stakes, even if it looks like
Ross
just arguing
Jr.,
back
who was
and
placed
forth.
on community supervision in 2024 CR 008733 for the offense of possession of a controlled substance, penalty group 1B, 4 grams to 200 grams on February 13th, 2025 for a term of 9 years. Is that you?
Yes, Your Honor. I do.
State?
Condition number 2, on or about the first day of May 2025 in Bexar County, Texas, the defendant, James Ross Jr., did then and there illegally use amphetamines and violence.
How do you plead to that? True or not true?
True, Your Honor.
Violation of condition number 2, on or about the first day of May 2025 in Bexar County, Texas, the defendant, James Ross Jr., did then and there illegal use cocaine in violation of condition number 2.
How do you plead to that? True or not true?
True, Your Honor.
And then violation of condition number 4 in Bexar County, Texas, the defendant, James Ross Jr., did then and there fail to report to the supervision officer as directed for the months of May and June 2025 in violation of condition number 4.
How do you plead to that?
Not true, Your Honor. To one of them.
All right,
I
not
did not.
true to which one?
I did not.
Waive violation of condition number 1, 4, and 14, which is
Any objections to the waivers?
None.
Did you understand by pleading true to violations 2 and 2, the court could find it true, grant the motion,
Well, you know what?
and sentence you up to 8 years in the prison and up to $2,000 fine? Knowing that, do you still wish to plead true to violations 2 and 2?
That the court's only option.
Notice the legal nuance. Pleading true to some violations means the court could impose maximum penalties. Even if the attorney and state reach an agreement, the judge isn't bound by it. This is why procedural knowledge is everything in
For
probation
any
hearings.
violation, it could be for littering. Any violation that is presented by pleading true, the court could sentence you to 8 years in the prison. Will I sentence you to 8 years in the prison? I don't know. I haven't heard anything with regards to that. But that is what you're looking at. And what I can tell you, whatever agreement you worked out with the state, if you have worked out an agreement, the court doesn't have to follow that agreement because this is a contract with the court. It's not a contract with your attorney. It's not a contract with the state. So by pleading true to 2 and 2, you are looking at a potentially 8 years in the prison and a $2,000 fine. Knowing that, do you still wish to plead true to violations of 2 and 2? That's either yes or no.
Yes.
Court will find 2 and 2 true. Is there a proposed agreement?
Not to grant the state's motion, and of those two defendants can use supervision and sentence him to the 8 years in the prison based on the plea of truth here today, and then based on the underlying facts of the case that he's placed on probation. The state made punishment enhancements through that and recommended community supervision was done by a prior APA. And based on that amount that was in possession of at the time of the offense, and continued use and possession of controlled substance.
All right, defense, what are you requesting?
Well, asking for drug treatment, Your Honor. I mean, he's on probation. He tested positive for some substances. It was obviously consistent with use. We all.
Defense is asking for drug treatment, pointing out that relapses happen. This is the human side of probation hearings. The court has to balance punishment with rehabilitation. Do you think the judge should prioritize treatment or the violation
relapses. He was on
itself?
probation for a drug offense, and he made note to me. He said the judge told me when I pled that if I ever have problems, to contact the probation department to let them know to work with them, and that reflects well on me if I ever came back.
Did he do that? And I'm not considering it because I know the number 1 was waived. However, inpatient treatment is not going to be available for him until that case is, whatever is done with that case. All right. Any objections to that witness being by Zoom at 1:30?
None.
All right. So, Ms. Abrams, if you'll let her know, we'll be back at 1:30, and if she can look through her files between now and then. All right.
A warrant for his arrest.
Yes.
Okay. And what did you instruct him to do when you spoke with him on June 9th, 2025?
Once I spoke with the detective and he verified that the warrant was active, I instructed him to turn himself in and handle the warrant to clear it.
Okay. And to your knowledge, was that done? Well, actually, let me rephrase the question. Did you speak with the defendant again on June 12th, 2025?
June 12th. No, I do not have record of that conversation. No.
Okay. Did he ever ask for any help specifically regarding substance abuse?
No.
Okay.
I just want to get some clarification. You said there was a positive drug test on May 1st?
It was May 1st, yes.
And where does that drug test take place at?
He goes to either recovery downtown or he can come here on Mondays and Thursdays here at Bandera location.
Could you please tell us where that May 1st test was taken at?
It tells me RMS, but I'm unaware if it's Bandera location or downtown. I just know that it's RMS.
And what does RMS stand for?
recovery medical services or something like that. Yeah.
Is that the test provider?
Yes, that is. That's where they go and submit their drug test.
Okay. And so what you're saying is that your notes are inconclusive as to whether or not he came into your office in the month of May.
In the month of May, yes.
Here's where things get tricky. The probation officer's notes are inconclusive about whether the defendant actually showed up for drug tests. Small gaps like this can have huge consequences. This is a reminder that record keeping in legal
aware
matters
if he
is
came
critical.
here or downtown.
Okay. And when he comes to your office, I imagine he doesn't direct himself as to what to do when he arrives.
When he comes for a drug test, he's not to check in with me. He's only to check in with the drug test providers when they're here. So regardless, I wouldn't have known if he was here or not because he does not check in with me when doing drug tests.
Okay. Were you available that day when he showed up?
I'm not sure if I was available or not. He didn't ask for me or anything. I probably was in a meeting.
Okay, fair enough. Now, my next question is, did you receive a call from him on June 1st?
June 1st. Let me check.
Are you aware of the offense date of the alleged, I think it's new number 1 in the MTR allegations?
Let me check the MTR. I have it pulled up. The alleged date is June 1st, 2025.
Do you recall speaking to James Ross about that new number 1, the day that it happened? Did he call you or speak to someone at your office?
No, not on June 1st.
So my question to you is, do you document any and all communication with the client or just those that you deem to be relevant?
All of them.
And it's your testimony that you did not speak with James Ross. Call Mr. Ross.
All right, could you rate, you're still under oath. All right, you may proceed.
Just one more. Mr. Ross, on the date of the new alleged number 1 against you, did you call the probation department or Miss Dixon that day that it happened?
I did.
Who was with you when you made that call?
Twanya Monday.
Who was Twanya Monday to you?
All right, first of all, for the record, if you could spell the first name.
TWONYA.
All right.
And what date do you recall speaking to Miss Dixon?
It was the date of the alleged robbery. I believe it to be the 1st.
The 1st of what month?
June.
Is that a 2025?
Yes.
When you called her, did you reach her directly or were you rerouted to her when you called a general number? How did that work?
I reached her directly. I called to the office.
Okay. When you spoke with her, did you identify yourself?
I did.
Did you communicate to her about your circumstances and what had just happened to you?
I did. Told her I was worried that I was going to get in some trouble with this woman who was not trying to pay me for the work I'd done.
Okay. Now, without getting into the facts and circumstances of the case, why did you feel compelled to call Miss Dixon on the date that this incident happened?
Because after me and my girlfriend left, I saw police shooting past us in the opposite direction from which we came. So I felt like she'd called the police.
Okay. And you wanted to, as a result, make sure that you talked to probation and let them know about this alleged incident.
Right, I did.
Now, after June 1st, when is the next time you spoke to Miss Dixon?
When the detective contacted me to come to an interview with him.
And what day was that?
I don't remember the exact date.
Was it the same week as the incident?
I believe it to be, yes.
She's testified, I believe, that it was June 9th. Would you dispute that date?
No, I wouldn't dispute it.
Okay, sounds familiar to you?
It does.
Okay, and as a term and condition of your probation, you know you're not supposed to have police contact, correct?
Right.
And the detective would qualify as police contact. Is that fair to say?
It is.
And as a result, you wouldn't contact the probation to let them know about that contact.
I did.
Now, on June 16th, Ms. Dixon has indicated you sent her an email. Do you recall doing that?
June 16th?
Or whatever day you recall sending an email.
I do. That sounds familiar because I sent the detective the same a copy of the receipt from the Cash App transaction, and then I also sent it to my probation officer so someone else would have it besides just a detective.
And again, we're not getting into the facts and circumstances of the case. We're just talking about communication.
Right.
And that email was sent around the 16th of June, 2025.
Yes.
Okay. Now, there was also some mention that you paid a fee. You recall doing that?
I do. I was trying to stay current on my probation fees.
Did you contact anyone at probation before you made the payment or after?
I don't recall.
How did you make the payment? Online, or did you go into the office?
Online,
Okay.
I believe.
All right. After you made that payment, did you hear from Ms. Dixon at all?
Yes, after she spoke with the detective. Next day, after she spoke with the detective, she instructed me that I should go and turn myself in.
Okay. And I'll leave it there. Thank you. No further questions.
All right, any questions?
Yes, sure. All right, Mr. Dixon, so you're here, or Mr. Ross, you're here because you're on probation for possession of a controlled substance, PG1 or 4 to 200 grams. Is that correct?
That's correct.
Okay. And so I want to take you back to May 20th of 2024 when you were placed under arrest for the offense that you're on probation for. Do you recall that date?
No.
Okay. And so that date you were traveling in a motor vehicle. Is that correct?
Yes, it was not mine.
Okay. But you were in the driver's seat, correct?
Correct.
Okay. And you were with another person on that day that was in the passenger seat, correct?
Correct.
Okay. And so the officer pulled you over for a defective headlight. Is that correct?
Allegedly.
Okay, well, you understand that this was stipulated to, correct? When you took the plea, you said it was true and correct. You remember that?
Well, Your Honor, I'm going to object at this point.
Okay,
For the simple fact that if he pled no contest, the court simply establishes a record. There's a basis to prove the case beyond a reasonable doubt. That doesn't mean he's agreeing necessarily with everything in the report.
well, Judge, and I can ask him about it because it's part of the stipulations in the court's record, and it's going to whether he's actually a user, as they're claiming, or whether he had other intentions with the Controlled Substances Act.
All right, the objection is overruled.
Okay.
Just really quick, I'm just trying to clarify so we understand. This line of questioning is about whether or not he's a user of drugs versus a seller of drugs, and he's on probation for using.
His estate waived the first count. So if I'm getting to blame my predicate as to what was found on him.
Okay, and he tested positive for drugs while on probation, which is use as well.
All right,
Users can.
the objection is overruled. The court will hear the question and the answer.
Okay. And so you understand that the officer stated that when he approached the vehicle that he smelled an odor of marijuana, right?
Understand that to be so.
Okay. And so when the officers searched your person, in your pocket, you were in possession of a scale. Is that correct?
Allegedly.
Okay. If that's in the stipulations, are you now disputing or contesting that?
I don't recall.
Okay.
That day it was lights blinded me in my face. I was snatched out the car and everything happened so fast. I really don't remember.
Okay. And then after that, you were in possession of 13.
That's not correct.
Well, I guess let me rephrase it. It was actually 17, but by the time it got to the lab, it was 13, correct?
Well, I'm going to object to that line of questioning because there's a field test and there's admitted labs through a state certified crime lab